So welcome everybody tonight as we do another night of our SALT Talks. Tonight we are going to talk about understanding special needs trust with Laura Drake. This month we covered so many topics, everything from Social Security to financial planning to stable account, and all of them kind of touched on special needs trust. So I thought it was a good idea. We're going to end this month on a special needs trust, which will also lead us into our next month, which is how do I plan for when I'm gone? What do we do as parents to plan for when we're gone? We have to plan for, beyond our passing. We got to get our kids ready. As parents, we have to be prepared. So this kind of ties in both months, this topic tonight. So it will be the end for our financial planning, but it's going to be a kickoff for our next month in a sense. So I am going to turn it over to Laura. And for those who don't know who I am, my name is Patty Schramm, the Parent Resource Trainer for the SALT Talks. We'll post them again, but we did post some links for tonight's presentation, just so you can get to the hard copy of it when you want to look at it, and then some other resource links. So with that, I'm turning it over to Laura. And Laura, I have you as co-host, so you can share whenever you're ready.
Let me give a little chat first. Hi, everybody. My name's Laura Drake. I am an attorney, and I'm the associate director for Southern Ohio for Community Fund Ohio. And Community Fund is a special needs trust organization open for family members or for individuals who live in the state of Ohio. Community Fund is actually one of the largest special needs trust organizations in the country. We think we might actually be the largest, but not everyone gives all their information out. But we have over $100 million on trust. And we were started back in 1992. 80 of the 88 county DD boards contributed money to create Community Fund for the benefit of their clients. But it's open to all 88 counties, even the 8 who didn't cough up any money. They still get to, those people, everyone gets to use it. So, and I don't know the 8 counties that didn't give. I have an idea, but I don't know for sure. Anywho, so back in the day, if you had a child with a special needs who had any kind of disability and who was going to get needs-based benefits. And so that is what when we think of needs-based benefits, it means we have to declare how much the individual makes or has on hand. And so that's SSI and Medicaid. Those are the 2 big ones we talk about. HUD, housing assistance, that's also one, but that doesn't come up quite as much. So those are needs-based benefits. And if you had those, you had to have, it used to be you had to have less than $1,500 in the bank. And which, for a lot of people who need SSI and Medicaid, they had less than $1,500. It wasn't a big deal. But eventually, sooner or later, you're a passenger in a car that's in an accident, and you receive some sort of award for a personal injury case, or Social Security redoes the math and they give you a back award. And so suddenly you're getting your $600 a month at the time, and then you get a $4,000 back award. Well, that's going to put you over the $1,500, which Social Security had a way of dealing with that, but Medicaid didn't. And other things like that happen, or mom and dad don't do planning, and one of them, or some distant aunt dies and leaves you some money, and you didn't expect that was a problem. And so there were a couple things you could do. If mom and dad were planning ahead, they could do something called a spendthrift trust. Those were very impractical, and they weren't used very often. But mainly, attorneys were told to disinherit the child. Told them to disinherit the child. Don't leave anything to your child with special needs. Leave it to their siblings and hope they take care of them. That was a pretty common thing. Or if the individual inherited the money, they had 2 options. If it was a lot of money, they basically had to give up their benefits until they spent it down. And if it was a small amount of money, they had to blow it really fast. And this is true. In some of the smaller counties out east, they would tell people, like, you know, you could only have $1,500, and a gazebo costs $1,500 from the Amish furniture store. And so when anybody was getting close to that amount of money, if they didn't need another TV and furniture or anything like that, they'd go and buy a gazebo. And there were some homes that had 2 gazebos in the front yard, because, you know, 1 gazebo is not enough. You need 2 of them. So that's what you saw. You saw some wasteful actions, and really it was the only thing to do, because if I only had $1,700, losing my Medicaid didn't make any sense. I couldn't do anything with it, and I had to get on Medicaid again instantly afterwards. It was crazy. So, so people blew the money. Well, in the early 90s, Congress finally saw that this was a problem, and they allowed for this creation of what are called pooled special needs trusts. And they created the idea of something called a wholly discretionary trust, which means the trustee has complete and total control what the money is going to be spent on. And that meant that these could qualify for individuals who had disabilities, because in a regular trust, if you were going to meet with an attorney and set up your estate planning, you would do a revocable living trust that has a standard of care. And it says, please provide for me and my spouse and my children's health, maintenance, medical, and support and education. All right. Well, if it's providing for their health, that's what Medicaid's supposed to provide for. Support is what SSI covers, right? And so, and you know, and medical and all that, you know, that's Medicaid. And so because of that, if that's the standard of care in a trust, and there's money in the trust for the benefit of the child with a special need, there's no reason for Medicaid or SSI to cover them, because there's all that money in the trust that can pay for them instead. All right. So that's why if I had a child with a special need before the 90s, it was very hard for me to leave them money, because if I did, it was going to be spent so quickly, because their care needs were going to be so expensive. They couldn't keep the money for those extras in life. So in the 90s, they create a system called for wholly discretionary trusts. And that's what we're going to talk about. And a wholly discretionary trust says it is entirely up to the trustee what to spend the money on, and nobody can force them to spend it on anything. And that's important, because that means the state cannot demand that the trustee pay for their health and wealth, and for their health and maintenance and support. And so now the money in a trust, in a properly drafted special needs trust, is not an asset. And because it's not being used for their daily needs, it's the individual gets to keep Medicaid, they get to keep their SSI check, and they get the benefit of this trust money. All right. And so this is the big game changer. And so now, and I'm going to talk about trusts and how they, why is it not working? There we go. I'm going to talk about trusts and also with stable, because these things, but we're going to talk now about, about trusts, pooled trust versus private trust. So I've given you this back overview of trusts. When you did your estate planning, you would do a private revocable trust. And then that's a little bit better. Oh, that's way better. So if you will just scroll down just a little bit. So there we go. So when you talk about drafting up a trust, the big thing is deciding like who to go to create a trust. So you know you need a special needs trust because you have a child who's getting these benefits that are asset based. So you can use a pooled trust organization like Community Fund, or you can have a private trust. And neither is right or wrong. It depends on the situation that you have in front of you. So if the majority of the asset that you're going to leave to your child is your home that you intend them to live in, then more than likely you're not going to be able to use a pooled trust. To the best of my knowledge, there's only one pooled trust organization in Ohio that will take a house, and they won't always take a house. Most pooled trust organizations just want to deal with cash. So if your big goal is to create a trust where your child gets to live in your house after you pass away, and you have it in the trust, because then after they pass away, it goes to your other kids and doesn't go to Medicaid, then you're going to have to look at a private trust. And if you're going to go with a private trust, you're going to have to hire an attorney, and you need to make sure that they know about Medicaid and Social Security. and that they understand what they're drafting. So they're drafting it to preserve all the benefits your children need. And sometimes that kind of goes against what you might know. And this is a story, an example that came up a long time ago, where a woman went to the attorney and said, my child will never need Medicaid because my pension, that I have from my employer provides my child health insurance even after I pass away. And so you do not need to draft a trust that protects Medicaid. And because of this pension, they'll get more than just SSI. So you don't have to worry about that either. And the attorney who drafted the trust was not an expert in the field and didn't understand that Medicaid, there's different types of Medicaid. There's food stamps, that's Medicaid. Her child wasn't going to need that. There's health insurance, that's Medicaid. Her child wasn't going to need that. And then there's long-term care and waiver services. And so if you and I go into a nursing home and we run out of money, we don't have any more cash, we're going to go on Medicaid. All right. That isn't just our health insurance, because I assume we're going to be older and we're going to have Medicare. That's also the actual staying in the nursing home. So that covers the cost of us being in a nursing home. It's not technically medical care, it's nursing care. And when you have a child with a special need, you've probably heard about the waivers, right? The health, the self, the help, and the IO waiver. Those are Medicaid. And it's true that when this parent was alive and was caring for their child, and that the child didn't need those waivers because mom was providing all the care for them. And so in mom's mind, her child didn't need Medicaid because she was going to have health insurance. But the minute mom passed away, the child needed the IO waiver. Because even though the kid could live in the house, it was set up for that the child would stay in the same home, there was no one to actually physically care for the child, right? Mom wasn't there anymore. And the child, an adult, needed round-the-clock care. Well, that's $80,000 a month or some insane amount of number. It's not quite that, but the waiver is close to that. It's a lot of money, the IO waiver. And because the trust had not been set up properly, had not been set up as a special needs trust that would protect the money from Medicaid, the child wasn't eligible for the waiver. And so they would have to private pay for caregivers, round the clock caregivers, because the child couldn't get the IO waiver. And so that's why it's so important that when you're picking an attorney to draft your private trust, which is going to protect the house for the benefit of the child and anything else, that they know what they're doing. Because if they don't, you had this situation where in the end, everything had to be sold and liquidated. And there were no remnants of it because they needed the waiver. They had to have the waiver. There was no other way for the person to stay in the house. They did get to keep the house for a short period of time. But ultimately there wasn't enough money to be able to continue to do that because the trust wasn't set up properly. So finding that attorney is really important. There are resources. You can always email me, and my email's at the bottom of this document. You can always email me and I can give you a recommendation. I can give you a list of attorneys to do these kinds of things. There's also something called the National Academy of Elder Law Attorneys, which is, they have their own website and it has attorneys. And a lot of elder law attorneys also do special needs. Not always, but there's quite a bit of overlap. So if you do the private trust, finding that attorney is so important because that is the number one step to make sure that whatever's created lasts. Now, if you decide to go with a pooled trust, that's not necessary because the pooled trust organization like Community Fund, they have a trust and you, the family, are just joining it. So at Community Fund, we actually require you to hire an attorney because to give you advice as whether or not Community Fund is really the best choice for you. It might not be. And we want to make sure you have your own individual advice that you're getting. But then you just give them data then to set the trust, to set up your own account within the trust. And so it's a much easier process than having a private trust. It should cost significantly less than setting up a private trust, significantly less. And there's less likely that there's any kind of long-term problem. Two reasons. One, community fund the trusts have been approved by Social Security, so they're out there and they've already been approved by Social Security. And then also the trust can be fixed. So once upon a time, Social Security did not allow you to buy clothing from these trusts, but they've changed that rule. So when there was some sort of revision, we just addressed that, and now you can buy clothing from these trusts. If some of the older trusts, we never actually had that limiting language, but some attorneys, when they set up these private trusts, they would put limiting language in these to reflect what the rules were when they drafted the trust, but the rules change. And so with community fund, it's a living document, so it's easier for that to change at no cost to the families. So that's part of the decision-making process about which trust to choose. If you're going to choose a private trust, you have to understand you have to hire an attorney who's very knowledgeable about it. You might, you really need to research that and make sure you're getting someone who's properly who's properly trained in that. So then the other aspect of this is who's gonna figure out what to be spent, where to spend the money, who's deciding who's dispersing the trust funds, and that's called the trustee. And the trustee is the person that you have entrusted. Sorry, there's no way around it to use the word trust overwhelmingly when we talk about trusts. It's because that's the underlying concept of it. So the trustee is the person that you've entrusted to disperse money from the trust. And oftentimes in these private trusts, you name a family member. That's pretty common. In a private trust, you name I'll name my typical child, the sibling of the individual. I'll name my own sibling, though that's dangerous because they're the same age as you. So you've got to have somebody, in the next generation. Or you might name a bank. And that's usually a lot safer, but there are fees associated with that. Banks are for-profit institutions, and they're going to usually charge, you have to figure they're looking at about 2% of the principal balance a year. So if you have, $500,000 in the trust, then they're going to take their $10,000 fee a year. So plus any investment fees. So that's if you choose a bank. If you go with a family member, they're not probably they can take that same fee, just to be sure they can take that fee. Many times they don't, but they're entitled to. But the question there is, do they have the knowledge to actually make the disbursements? And so that's the difference between a private trust and a pooled trust like community fund. In community fund, whenever anybody wants to request money, they've named someone, what community fund calls a designated advocate. Basically, that's a trust advertiser, a trust advisor who can request money to come out of it. And so they say, hey, I want to use this money to buy, I want to go to Disneyland. Okay, that's fine. You want to take the individual with a disability to Disneyland. Okay, that's fine. But what is the trust paying for? Is it going to pay for the individual with the disabilities airfare? Absolutely. Their hotel room? Sure. Eating out, that gets iffy because trusts aren't supposed to spend these kinds of trusts. SSI is supposed to pay for their food. So whether or not it pays for eating out becomes an issue. But will it also pay for a caregiver to go down? What about their whole family? No. A caregiver, yes. An entire other group of people, not so much. And that's important because if the trustee approves expenses that are not allowed under Medicaid and Social Security, then the trust can become invalidated. The Medicaid basically can say, hey, you're not using that trust like it's supposed to be used. You're not using it as a special needs trust to supplement the things that they're already covered for. You're using it as a day-to-day thing to cover all their expenses. And because that's how you're using it, we're going to treat it as an asset. And that's really important because if the trustee doesn't know what they're doing and makes some bad decisions and pays for things that they're not supposed to pay for, then the trust can actually get wiped out, can become an asset. Now they'll have language in there that says that if they're been even remotely properly drafted, that says something called a poison pill that says if they are deemed an asset, the money doesn't go to the individual, it doesn't go to Medicaid, it goes to the residual beneficiary. And the residual beneficiary is who gets the money after the individual with a disability passes away. Well, who does usually get that money? Well, usually it's actually the trustee, because usually you've named your typical child to be the trustee. And that's the residual beneficiary. So there's what I like to call an inherent conflict of interest when you name your typical child to be the trustee of the trust for your special needs child, because if they mess up, they just win. They get all the money right away. Instead of waiting for their sibling to pass away, it's theirs. Now, that doesn't happen very often, but it does happen. And so it's something that you have to recognize is out there. If you've named a bank, it's very unlikely that that would happen. It's like next to nothing. And if you go with a pooled trust organization, it's basically impossible, because that's their purpose of pooled trust organizations, is to ensure that nothing like that ever happens. That their job as a pooled trust organization is to make sure that any expenditure, any disbursement from the trust, any reimbursement or expense disbursement will not run afoul of either Medicaid or Social Security. That's the advantage of an organization like a pooled trust. The other thing you have to remember about pooled trust is they are not for profits. When the law, I mentioned earlier that in 1992, they passed the law creating these kinds of trusts. They are required to be nonprofits. And so because of that, they're usually not really trying to make a very large fee off of these. They're trying to cover their costs. And not to say anything against banks, because banks, they have a right to make them, that they are for-profit institutions. So they're going to charge a larger fee. And then because banks do all sorts of trusts, so if you say, I'm not going to name my sibling, the typical sibling, because that's going to potentially create a problem. And maybe they're not good with money, or maybe, they're easily manipulated by somebody else in their life. This is a problem. I'm going to name the bank, and that's fine. The bank is going to charge more than a nonprofit will. That's pretty obvious. They should potentially also get you a higher rate of return. They should be more aggressive in investing than a nonprofit's going to be. But the other thing you have to know with a bank, when you look into those, is you need to be really mindful about how many special needs trusts they do. Because if they don't do a lot of special needs trusts, they're going to be hesitant to make a disbursement without an attorney saying that it's okay. And when they hire an attorney to determine whether or not they can do a disbursement, whether that's an allowable expense from the trust, they're going to charge the trust for the attorney's fees. So it's something to think about. Whereas a pooled trust, that's their job. So they cannot assess a fee against the trust. They should not be assessing a fee against the trust, because they had to determine whether or not something could be expended. Now, I know at Community Fund, we have a panel of people who work in the field. And if we're unsure whether or not we can make a disbursement, we bring the panel in, and they're all volunteer. And we make a judgment call about that. But then we stand behind that, and we're willing to address that. So those are something to think about in that. Now, I did address a little bit earlier, what happens when the rules change. So hold on just one second. And the rules do change. Medicaid and Social Security, they revise the rules about what is appropriate in these trusts. They do it all the time. Usually it benefits the individuals with disabilities, but sometimes it gets a little more stringent, a little more specific. Well, if you have hired an attorney to create a private trust, then that private trust may need to be updated over time. That happens. And so then the attorney would have to the parents would have to go back to the same attorney, or potentially a new attorney, and make sure that their trust is updated. I will say that if the trust is drafted well, it should be very nondescript and have very few things in it that would require changes. But still, that's an issue. And then again, if you have a private trust, you need to expect that the trustee, whoever it is, will occasionally be paying for an attorney to make a recommendation as to whether or not an expense is allowable. And so that's some charge that you should be expecting. In a pooled trust organization like Community Fund, we update the trust agreement if there's been any changes with Social Security. About 7, with COVID, it's hard with time, but I think about 7 years ago now, Social Security said, all right, we're reviewing every single trust out there, every special needs trust. We're gonna have attorneys review them and go through them and look at them. And man, they dinged a lot of trusts. They went line by line through a lot of trusts. It took a few years, but they did go through them all. And so if you have a private trust and that gets dinged, that can be quite difficult to fix after the fact. Whereas the pooled trusts, many of them throughout the country were actually deemed not valid, but the way they're set up as nonprofits, they're pretty easy to amend and correct and revise. And when that happens in a pooled trust like community fund, that's an expense that the trust has to cover. It's not assessed to the individual pooled trust to the beneficiaries. That's just part of the operating expenses. Whereas if you have a private trust, that's a fee that you're going to have to be covering entirely out of pocket. And so that's something to think about when choosing which type of trust to use. Those pooled trusts, you tend to know what the costs are going to be going in, and there's really not going to be any fluctuation. Where in a private trust, you have to take into consideration that there are going to be costs that you just didn't see coming. All right, so we can scroll on to the next page. Cool. All right, so let's talk about the costs. So like I said, in a private trust, if you go with a bank, it varies, but it's usually about 2% of the value of the trust. So then obviously if it's a family member, they don't have to assess that fee, but they can. And it's whatever the going rate is for a bank, it's going to be what the family member can take also. And then in addition to that, any investment portfolio advisor costs, so buying and selling stocks and real estate investment, whatever they buy, all of those things are going to have to be covered. All of those will be paid in addition. And then they'll have to hire an accountant to prepare all the necessary tax documents. And then, like I said, if they have to make any kind of disbursement, they might need to hire an attorney who specializes it to review whether or not that disbursement is allowed. Some trusts will also charge additional fees for like writing checks and things like that, but usually banks shouldn't be doing that. So what about pooled trusts? Well, they vary dramatically. I have seen pooled trusts that charge almost no upfront fees, but then every time they write a check, it's $25. Well, that can add up. And if you've ever paid a copay on a Medicaid for a prescription, those copays can be like $2.81. Okay, well now it costs you $25 to write the check to reimburse the copay. That's crazy. So if you're not going with community fund, if you're looking at the other pool trust, you really need to make sure you understand, yeah, maybe they don't charge a setup fee, but they're going to get the fee later on. And they're going to get it in ways that are kind of shocking, is what I've seen. So community fund, let's say that you're setting up the trust, you're going to leave money for your child. So you want to put money aside for that child. So you're going to create what we call a dry trust. And then you're going to pay $750. The trust exists, but there's no money in it. And the reason you might do that is one of the biggest assets people leave their children is life insurance. And so once you have the trust set up, you have a tax ID, and that life insurance policy can go directly to the trust, which avoids a lot of wills and other trusts and things like that. So that might be the reason you would do that. There's no fee, again, until there's more than $15,000 in the trust. So if you set that up today with $750 and the only thing going in there is a life insurance policy, and you don't pass away for another 40 years, you will not be assessed any kind of fee until you're 41, after the life insurance policy goes in there. Then they're going to charge another $750. And then the next year, they're going to start charging the annual fee of $250 a year for the first 50,000 and 0.25 on everything over 50,000. So that is going to be way less than the 2% that the bank charges. Now, in 40 years, I don't know that we'll still be with Huntington, hopefully so, but right now, Huntington charges a trustee fee of 89 basis points on the investment amount, and that says annual, but I think it's actually done more often than that. But so I think I have to double check that, because I think that the fees actually comes out, I think quarterly, not monthly. So, but that fee that the trustee is charging, that Huntington is charging our trustee, that also includes all the tax preparation, writing all the checks, stop payment fees, legal, everything. It's all covered in there. It's all mapped into that. So, and any court costs that don't really come up very often. So the thing you have to realize is with a pooled with trust, there are two main types of trusts. What I'm talking about when I talk about you creating a private trust, and really for the most part, what I'm talking about with community fund is what's called a wholly discretionary trust, where this is your money. These are your assets, your life insurance policy, your house, the money you saved up, right? That's your money. And so that's a third party trust. And that money is going to go into these pooled trust or these private trust. Your child gets the benefit of that money during their lifetime. They get to use it for whatever they want. And whatever is left over is going to go to your other children. Okay. And, or at that point, your grandchildren, or if you don't have any other kids, maybe the charity of your choice, wherever you want it to go, that's where it's going to go. That's different than what we call a first party trust. So remember I said earlier, your child's in a car and there's a car accident and they come into some money or they get a back award from Social Security. Those kinds of trusts are called first party trusts. So, and we see those come up, right? Grandma doesn't do any planning and leaves your child $100,000. That's very nice, but it's going to create a little bit of a problem for you because now that $100,000, they're not eligible for Medicaid or SSI anymore. So in those situations, there's two options for those. And you guys learned about the stable account earlier this month, but presuming you didn't learn about it, I'm going to go over it a little bit. Stable accounts are savings accounts of sorts for your child. And you can put, or, for anyone who has a disability, based on certain rules, but basically anyone who has a disability can put a certain amount of money each year in, and it increases every year. And it's around $16,000 a year now. So you can put $16,000 a year into that account. Okay, great. If you come into an SSI back award for $10,000, you are not going to create a pooled trust. That's not necessary anymore. If you actually sent community fund a check for $15,000 saying we're creating this pooled trust for our payback trust for our child because they came into this amount, we would say, like, why are you doing this? What? Just no, put it in stable. Why would you pay us our fee? That's crazy. Don't pay our fee. Just put it in stable. It's way less expensive. We would stop you and make sure that you've investigated that before we set up the trust. And because that is the stable account is a much lower threshold. It's a lower cost. It doesn't have the fees that we have. And that's really important. And it has this, it has the same protections. That's we're talking about your child's money, right? We're not talking about your money because the stable account in theory has a payback provision. And so, and that's why that's allowed. And so when it's your child's money, we have to make that money available to Medicaid when they pass away versus your money. Your child should be able to get the benefit of that during their lifetime. But if they never use that money, if there's any money left in the trust that was your money, it can go on to your other children, your grandchildren, charity of your choice, wherever you want it to go, because you're basically letting them have the benefit of it, but you're not giving it to them outright. Remember, it's not their asset. It's really kind of always yours, but you're usually dead, so you don't want it either. Usually we don't fund these until we passed away. So there are these two trusts, right? So there's the wholly discretionary trust, the third party wholly discretionary trust, and then there's the first party special needs payback trust. And that payback is important. It's because this is your child's money. They should lose Medicaid or SSI, but instead we get to put it into either a stable account or a payback trust. We get to keep our benefits and spend the money slowly over time. All right, so that's really an important thing to know. And now you say, and again, the stable account fees for a resident of Ohio, it's nothing basically to set it up, and it's a couple dollars a month to keep the account. So it's going to be way less than these fees. And this is where it's important to understand a little bit more about these special needs trusts. I've alluded to the fact, I've mentioned that you can't use the money for just everything, right? You can't pay medical bills for it if Medicaid will cover it. You can't pay for housing because Social Security pays for housing. That's what it's supposed to. I know it doesn't cover it, but that's what it's supposed to. You can't buy food with it. That's a no-no. You can't go to Kroger and do your grocery shopping with money from the trust. It's not allowed. And then you say, but wait, I'm leaving them their money so they can live in a nicer apartment and have better things. What's the point of this then? Well, here's the beauty and why it's so important. Trusts, these trusts, either a private trust or a community fund, a pooled trust, you can take the money in from these trusts and you can put money into the stable account going forward. So during your lifetime, how much you put in a stable account is kind of up to you. There's some caps before you lose SSI. There's some other issues. But if your child needs to spend about $10,000 a year on housing and food costs that SSI doesn't cover, well, community fund can put $10,000 a year into their stable account. Now they can do it, on a monthly basis. They can put, $900 a month in to get to the 10,000 a year. I think that's about the right math, which is shocking. They can put it in a lump sum. That's not necessarily always the best idea, but they can. And they can put that money into the stable account. And then now this money that was in a trust that could not be used to pay for housing and could not be used to pay for food. Once it's in the stable account, you go to Kroger, you can pay your rent, you can pay for the heating bill, the electric bill, you can pay for anything you need to. The limitations on stable accounts are much smaller. They won't let you spend money, I think, on gambling and alcohol, and probably something else that, they have some moral limitations, but they don't have any limitations otherwise on what you can spend the money on. And that is really important to understand that now these wholly discretionary trusts where you're putting your money into this account along with the stable account, you're able to use that money for anything, to cover any and all expenses and things that you wanted to buy for your child, right? That you want to make sure that they have that they have available to them. So then one of the things that I'll get asked is, well, why don't I put more money in the stable account? Because, that seems like a better idea. And there are some benefits to it. There's a limitation. If you have $100,000 in the stable account, you lose SSI. But if you're over 65, your child's going to go on to your retirement anyway, and they're probably not going to have SSI. So we might not care about that because they might just be getting your, Social Security for adult dependent children. And then they don't need the SSI, so that wouldn't be irrelevant. But you have to remember that you can only put a small amount into these accounts each year. So you'd have to be funding it yearly. You cannot fund it all at once on your death. That's not possible. So you'd have to be funding it yearly and giving that money up. Because again, once you put it in that account, it is your child's money. It's not yours. So that's a problem with that. Also, there's no actual oversight on a stable account. So it's an online account, kind of like an E-Trade or any e-bank, and whoever has password kind of has control. So it would be very easy for someone to wipe out the account, quite honestly. I mean, honestly, it's true. And we talk about this at Community Fund. A lot of the things that we've had to do since we started in the 90s is put in safeguards to protect the beneficiaries. And honestly, we're overwhelmingly protecting them from their own families. So we have a lot of children who have received awards because of like a medical malpractice or something like that. And there's a lot of money benefiting a minor child, and it's the parents who's requesting the money. And we are oftentimes kind of having to explain to the parents that no, the child is not going to be paying for this, which really benefits the whole family, not the child. We didn't have this from Community Fund, but I'm on a listserv of like, hey, what do you guys think about this? And they're interesting examples. A family wanted to use the money from their child's trust. It was like there was $600,000 for the 8-year-old child, and they wanted to use $130,000 of it to buy a handicap accessible RV. But the child doesn't live with them. And so they did some investigation, and it ends up that the family goes RVing all the time. But they bring their handicapped child, the child who had like she had mobility issues. They bring her with them twice a year. That's it. But they wanted to spend, you know, 1/6, more than 1/6 of the trust for an RV that she would get to use 2 weekends a year. And so, you know, what the trust what the trustee had to go back and explain. The trustee had to go back and explain, no, we're not going to spend that kind of money for this RV, but we're happy to pay to rent a handicap accessible RV 2 weekends a year. So, I mean, whether the family was recognizing that what they were doing was absurd or not, I don't know, but seriously, it was absurd. You know, the number of times, one of the things we have to do is we have to look and see how often have we paid for this recently. The number of times we'll get a request for the same washer and dryer, like we buy a washer and dryer and then 18 months later they need a new washer and dryer. Like, you know, like they don't go bad that fast. The current thing that we have to pay a lot of attention to is when we're paying for clothes. Remember, I said once upon a time, we couldn't use the money in these trusts to pay for clothes, but now we can. We have to pay attention to what size the beneficiary wears, because we get clothes for the opposite gender and sizes that they clearly aren't. And when we push back on this, we're often told by the beneficiary, by the designated advocate, the person who's requesting the money, that they're disabled, their special needs sibling is a cross-gender, transgender, cross-dressing individual. And so then we have to reach out to the facilities and find out if that's true. And oddly, it's almost never true. Because even if you're cross-dressing, you tend to still wear clothes that are your size, not somebody else's size. So yeah, and this is pretty common. And this is where a lot of my, who am I going to choose as the trustee comes into play. I always tell a story. So my aunt was developmentally disabled, and my grandparents died when they were exceedingly young. They were in their 50s. They just turned in their early 50s. They were 52 and 53 years old. And so my aunt was just 30, and her uncle, my uncle, her brother was 19 when his parents passed away. I will not tell you how old my mother is because she gets upset. And she was 30. Anyway, they were Irish twins. And so when my grandparents passed away, they owned a business, they owned a company, and they owned a home, and they had a vacation home. So they had a decent amount of money. And they did what you did in 1972 when you had a child with a disability. They disowned her, and they gave half to my uncle and they gave half to my mother. And the understanding was that they would cover, you know, whatever my aunt needed from their share. And my mother still to this day feels they haven't really spent her third. And my uncle felt they'd spent her third, 25 years ago, 30 years ago. And he didn't want to, he wanted to start taking her $50 a month that she used to get to keep her Social Security to prepay for her funeral benefits. And I remember my mom saying that was not going to happen, that they would spend the money on her and then they would pay for her funeral out of their own money when she passed away, that they're not going to take her $50 a month of fun money and do that. And my mom once telling me, like, if I die first, you make your uncle pay for half her funeral. And I was like, oh, trust me, I will make him pay half. Because that was his experience about it versus my mom. They had a different expectation of what they were supposed to do for their sibling. And so that's why whenever I hear that someone is disowning their child with a disability and leaving the money to the other kids, I don't like it, because even if your children aren't like my uncle, who's, he's kind of selfish, let's say they get divorced. Well, if they get divorced, their husband or wife is entitled to half of whatever is commingled in their accounts. And so then potentially that money is not going to go to who you wanted it to go to. Or let's say you left it to, I leave it to my typical daughter, and then my typical daughter passes away soon after, and they have children, their money is going to their children. And if the typical daughter's children are under the age of 18, the court doesn't care what the intent was. the goal there is to protect the minor children, and the money will not be used for anything other than the minor children. And the thing is, everyone says, oh, what are the odds that happens? Well, I'm bringing it up because it happens all the time. These are common occurrences where the money goes missing. It goes to a sibling who's angry or upset or just bad with money. Somebody else passes away, and now suddenly the kids have it, the grandkids, and there's no way to get it out for the individual with the disability. And that's not what your intent was. And so that's why it's so important that if you are trying to plan for your child, that you plan for your child, that you take what they need in consideration, that you look at what the options are out there and what you're trying to leave to them and make a decision based on that. And so you're right. If you're saying, well, I'm not going to have that much to leave them, it's just going to be the house or a life insurance policy. If it's a life insurance policy, I'm going to really strongly suggest that you set up a pooled trust. That's going to be the easiest thing in the world to do. If it's a house, then you need to make some considerations, and you're going to have to probably spend the money to do and set up a private trust. If you only have the one child, you don't have anybody else you want to give anything to, but your child with a special needs, you do not have to put that house into a trust. You can give it to them outright. When they pass away, Medicaid will take the house. But if you don't care, what do you care? Now, if they're in the house and they can no longer live there, then someone's going to step in, sell the house, and put the money from that house, the sale of the house, into a pooled payback trust. And then with that, with a stable account, they can use that money in any way that they need to provide for your child. And then whatever's left in the trust is going to go to Medicaid when they pass away. So those are some basic options of how that can play out. But I think it's important to understand that these are all out there as different mechanisms to be used, in understanding this and why the trust is so important. But some people say, oh, I can't afford a trust. Well, the other thing you can always remember that you can do, you don't have to, we talked here about setting up the dry trust. Some people can't afford to do that, and they only have the house, and they say, okay, well, when I die, the house will be sold and then the money will be put into trust then. Okay, you can also just put it in your will that you want your executor to put any money that goes to your child with special needs into one of these wholly discretionary master trusts. In Ohio, you can do that. So there is a way, for a very inexpensive way now, to create a plan in place in your will saying, when I pass away, then I want the special needs trust set up at that point. And especially in the larger counties in Ohio, they're used to seeing this. They can address it. They know how to do it. They understand what these trusts are for. And so that's going to be a pretty easy way of doing things. Now, the other thing I would say is, if, let's say you're in Ohio now, I see this a lot in Warren County because of and Montgomery, because we have Wright-Patt Air Force Base. We have a lot of people who are kind of transitory. We don't know if they're going to stay here for a long period of time. Or even if you're saying, hey, once I'm done working, I'm out of here. I'm heading south for the rest of my life, or north, because the north is nice. I like snow. But nobody ever does that one. Nobody ever says when they're 80, I'm going to retire to the UP of Michigan, live in 48 inches of snow every winter. But if you wanted to do that, if you're not sure you're going to stay in Ohio, then you definitely don't want to make a decision about who the special needs trust is. Because like I said, Community Fund is only open to residents of Ohio. Now, if you set up a trust in Ohio and then you move to South Carolina, you can just transfer it down there. But why pay the $750 fee when there is the possibility you will not be staying here? And so in that situation, within your own estate planning, you can say, hey, executor, set up a pooled, wholly discretionary trust in the state that my child lives in when I pass away. Right? You can punt the decision until then. And so that, and that's a way of doing it. Even if you decide to go with a private trustee, if you're like, I don't want the full trust, I'm going to do the private trustee. My oldest child is a financial planner. They're so good with money. They'd be perfect at this. Okay, that's fine. And you're going to name them as the trustee. You still need, in your private trust, you need to make sure that your attorney gives them an out. There needs to be language in the private trust that allows them to disperse the money to a pooled trust. And that they need to be able to do that because they oftentimes will want to do that. It's actually way more work than anyone realizes until they're doing it. And as I always like to try and point out to people, they're becoming the trustee. Your typical child is becoming the trustee because their parent just died. You died, and they're sad and depressed because they just lost their parent. And now they've also kind of become the de facto parent for their sibling with a special need. And you've also now just put them in charge of controlling this trust and dealing with the money and figuring out whether or not to spend. And sometimes they have to decide what they want to spend their time on. And I always like to say, I'd rather I have a brother with a disability. I'd rather take him to his doctor's appointments than meet with the financial planner and determine how we're going to invest the money. Because that's not really that interesting to me. And I think he would benefit more from me taking him to his appointments than the other thing. And time is finite. And so I don't want to be the trustee. My brother's also exceedingly high functioning, and he would dispute every decision I made, and I don't want to deal with that. So I don't want to be his trustee. So because he's always like, but is this the best decision? And I would like to say, I didn't make the decision. That special needs trust company did, and I'm out. I'm off the hook. So so these are all things that have to be taken into consideration when making these decisions. And obviously, again, if you plan ahead, you have more options. If you don't plan ahead, if you don't put a plan in place, then the only option available is going to be this Medicaid payback pooled trust option. And with that, you can use the stable account, even with the pooled trust, right? The payback trust, you can still use the stable along with that. So you can use the money on anything you need to. But it really limits the next generation, right? And so that's why it's so important now to kind of plan ahead and understand what the options out there are. The other thing I get is, well, I'm going to wait until my child is 18 and then I'll make an estate plan. Okay. I mean, that's fine, but just so you understand, that's the age of 18 really has nothing to do with anything. So if you pass away, and you have not put a plan in place, then your children will each inherit an equal share directly. And your child who has a special need, when they turn 18, they will not be eligible for Medicaid. They will not be eligible for Social Security, for SSI. And because those are asset-based benefits, and they inherited this money directly. So when I hear that I'm waiting until they're 18, I'm like, yeah, that's a horrible idea. Just set up a simple trust that says my child who has a special need, their money goes into a wholly discretionary trust upon my death. It's just do a simple will, so it's protected, and then whatever's left over goes to my other descendants upon their death. There you go. That's all you had to do. And now, if something happens to them before the age of 21, before the age of 18, it's still protected. I think sometimes when I talk to families, and I understand this, they're not sure the extent of the disability, and they're not sure the extent of what the person's needs are going to be. And what I always like to tell them is these wholly discretionary trusts, it is entirely up to the trustee's discretion whether or not to give the money. The trustee is not going to give money that will impact their benefits. But if your child doesn't need benefits, there is no reason the trustee should hold on to the money. They should just be giving the individual whatever they want, because it's not going to impact their benefits. And that's a very important thing to understand. Also, in any special needs trust, the purpose of these trusts is to provide the individual with special needs the best life that they can have. So in most trusts, my goal is to save money for the next generation. In these trusts, my goal is to spend the money on the individual in the best way possible that they can enjoy and get the most out of their life. So it's a very different standard, but it means also that if they don't have a disability, if their disability is not limiting them, and they, like you set up this will that says this child put the money into a wholly discretionary special needs trust, and then it ends up they don't have a disability, well, then there's no reason that the trustee would keep the money. They should be providing that child, that individual, whatever that they need or want out of life. So All right. Whew, that was an hour of me talking basically nonstop. Now we're still here. I'm not done, but I do want to make sure you have my information. This is my email and my cell phone number that you can reach me. You can always email me and ask me for names of attorneys. You can ask me to go over this in greater detail. I have no problems talking to you about that. Sometimes families want to sit down and talk. It's weird because, during COVID, that completely stopped. I wasn't allowed to because, you could have killed me with COVID. But we're open for business again, so that's fine. And but I'm always happy to do that, to talk to families and help them out in any way. I always like to say that I love this job. It's so much fun because I will always tell you, yes, I'm an attorney, but I'm not giving you legal advice. I'm just giving general information, but sure, I'll answer any questions you have. But I'm not technically giving you legal advice. So, but I love to help. It's a lot of fun for me to do that. And in any way that I can to assist you to figure out your next steps. You can always email me. I live in this county. Do you know this attorney? Can you give me a list of attorneys? And I'm happy to forward the information that I have to you. If I haven't responded to your email in 48 hours, either this last few weeks, I was out with a horrifying ear infection and sinus infection, but otherwise I usually will respond within a couple of days. So, but also now I was going to ask if anyone has any questions, either in the chat or if you had any questions you wanted to ask. I know it's a lot of information, but if you want me to talk more about any specific aspect of it or part of that, I'd be happy to do that.
I see there's one in the chat now. Can you see that, Laura, or do you want me to read it to you? Okay.
I can see it. So the question is, can the parent be the trustee of the wholly discretionary trust with the successor trustee named upon the parent's death? So, so first of all, in theory, yes, absolutely. And normally you are going to be the trustee, but you really shouldn't be funding a wholly discretionary trust during your lifetime unless you know that one of you parents has a disability yourself, like maybe Parkinson's or Huntington's disease that might be pushing you into a nursing home. So normally we don't see, and that's a whole other level of planning, but normally we don't see parents fund these trusts until someone has died. So it's unnecessary to do that, but that is actually what you would do. You would be the trustee. It's just irrelevant because there's no money in the trust. And then the second part of that question, if the child never ends up needing SSI as an adult, can the trust be dissolved or changed into something else? Yes. So usually, again, because these are just revocable trusts that are complete, you can amend during your lifetime, it can easily be dissolved or converted over to a standard trust. But usually if they and we see this especially with autistic children who are able to go out in the world and work, people don't feel the need for this. But I would say sometimes you keep these trusts around because maybe they're out working, but they're not really great at handling their money. And so you keep the trust in place as a way to have a mechanism to control the money even after you passed away. But yes, if the child never needs SSI, if they're able to go out and work and do other things, and again, to me, it's not about SSI, because what you have to remember is that when you pass away or when you retire, your child is not on SSI anymore. They're getting your retirement benefits. So that's usually much higher than SSI. This is more about, to me, it's about the Medicaid waiver. Who is going to physically care for your child day to day after you're gone? And that is usually the waiver. But you're right, if they never need that, if they don't need transportation services or anything else, then the trust might not be necessary. So yeah, and they can be dissolved, especially during your lifetime. But even afterwards, you can, in Ohio, you can go to the court and say, yeah, this is just not necessary. They don't need this kind of trust. So it was based on the belief that the child was going to get benefits that they don't need and they're never going to need. So we want to terminate it. And in theory, that could happen. It's that we wouldn't normally bother to do that, but because again, it's a wholly discretionary trust. I can spend it on whatever I want. So usually, why bother? So. Do we have any other?
I don't see any other. Which can you, I was writing down just to review, a Medicaid liability, the ones for the payback and stable account they'll look at that. What was the other trust that they would be a possible payback or for Medicaid?
The pooled Medicaid payback trust. That's the first party trust. These are trusts
Okay.
where your child's social security number, his or her social security number, or the money was his or hers, right? So wages, an inheritance, they were in the car accident, they received some sort of settlement from a lawsuit, a back award from SSI, from Social Security. Those are all your child's money. And if we're going to put that money into trust, it has to have a payback. So either it's going into stable, which has the payback, or a Medicaid payback trust. And Community Fund offers two different types of trust. It offers the Medicaid payback trust and the wholly discretionary trust. And that's true for most pool trusts. They have both. And so that's why it's really important to know which one you need when you're organizing this. So you don't create you don't want to put a payback trust with your money, because what's the point? Your money your child can use it, and then whatever's left over can be used for everyone else, for your other kids. And so I'd like to give examples of things that the money in these trusts can be spent on, because I think it's kind of interesting. Because when I say you can't use it for housing and food and medical, people are like, well, what am I using it for? Well, so with medical, it can't be used. Anything Medicaid is going to cover, it can't be used for. But if Medicaid won't cover something, it can. So Medicaid might pay for XYZ, but you want XYZ plus AAA amazing one, you can pay the difference. It'll pay the difference. I always joke that these trusts are overwhelmingly used for Disney and dental, so vacations and dental work, which Medicaid does not cover. Also, we see a lot of service animals through the trust. That's a very popular concept. One of my favorites is bail. If you have someone who has a criminal tendencies, you can use the money to post bail. I always say our fees, we don't ever have, Community Fund doesn't have any hidden fees. There's one semi-hidden fee, and that is if you need money overnighted, we do charge you like $25 or $50 to cover the overnight fee. And we don't, and we really did it because people used to say everything had to be overnighted, and it was costing a lot of money. And now we really only see overnight fees for like bail. And that does come up every once in a while. But it can cover, it is amazing how it can pay for those extras in life that someone might not otherwise think that they need. And now that you can do clothes too, that's really nice because clothes are expensive. But also like any kind of furnishing in the house, upgrades, it can pay for the cell phone, it can pay for the cable bill and internet, but like I said, it can't pay for housing. Those aren't housing expenses, but gas and electric, trash removal, water, those are housing expenses. So that money, if you needed the trust to pay those, you'd have to funnel it to the stable account, and then the stable account can do this. And so someone else is asking, if I have a family inheritance on my side of the family and want to keep it in my bloodline, should I have my special needs trust for my child be the beneficiary instead of having all to go to my spouse if I should pass away first? Well, yeah, technically. Usually what we might do in something like that, like if you still want your husband to have some benefit of it, you might set it so the income from the inheritance, he can take advantage of that, but the principal is protected. So the one thing you want to do is if you inherit money like that, again, not giving legal advice, just to be clear, that you want to not commingle that with your spouse. You want to keep that in a separate account. But yes, if you want all that money to stay only with your kids, so in case he should remarry or whatever, then you would have to separate that out ahead of time. You'd have to make a plan. You could have it fund a special needs trust upon your passing, and then whatever your child doesn't use goes to your other children. If you're going to do that and you used something like a community fund trust, you might want to make that trust irrevocable from the beginning. And that way, if your husband wants to add more of his money to that trust, he can, and then whatever is left over will go to the children you two have together, or whoever you chose. If you have it not irrevocable upon your death and your money went into it, if you and your husband create the trust together now, and it's not irrevocable upon your death, he actually could pull the money out of our trust. So that's something you have to. So the point is, if you decide to do this with community fund, make sure you give us a call. But oftentimes when you have stuff like this, what we see is that you create a trust, and this money goes into what's called the family trust. And so your husband gets the benefit of the income, whatever, investment return it makes to his lifetime, but the principal is protected for the kids. That is something that you could do very easily. So, but I would say you really want to make sure you're meeting with a very knowledgeable attorney in this planning, and also they should have probably a little bit of family law experience. So to make sure they are addressing that aspect of it also. So
you had mentioned an elder law link. Can you clarify what that link is? We were trying to look it up.
Yeah, so I'm going to put this in. I'm going to put it into the thing. It's NALA, National Academy of Elder Law Attorneys, the national. So, and I put the link to their website. And if you go there, they have like a big red button. And it says find an attorney, and you can put in how many miles you're willing to go from where you are, and the field, the field. Now, I will say, if you live in a smaller town, you better be willing to travel. To me, I think it's, I think saying, oh, I'm going to go to this local attorney because I want to stay local, that's great if they know what they're doing. But I just feel like you have to be willing and understand that it might be worth your while to get in a car and drive to one of the big 3 cities in the state. Dayton and Akron, they have a lot of attorneys who specialize in this also. The east side of the state, it's going to get kind of iffy. It's worth it to invest the time to get someone who knows what they're doing, especially if you're setting up a private trust, because it's really, you'll be dead when it all blows up and goes to pot, but let me tell you, it's not what you want. And I've seen, and it's not, oh, I went to the biggest firm in town, and they know who cares? I've seen the biggest firm in town do the stupidest things because they don't really specialize in this. And this is a special field. Medicaid planning and disability planning is a very specialized field, and you want to make sure you're meeting with someone who that's a good focus of their practice. You need to ask them questions. You should ask them to tell you about the Medicaid waivers, and you should ask them, like, what's the difference between SSI and SSDI, and what does my child get when I die? If they don't know the answers to these questions, if you don't know those answers to these questions, you email me and I'll tell you what they are. But if the attorney doesn't know the answers to these questions, run away. And I've said this, I haven't said this in a long time, but I really want to make sure you guys feel confident knowing that when you go and meet with an attorney, if you get that feeling like, I don't know, run away. Maybe they're going to charge you $250 or $300 to have met them, and that sucks. If you never pay the bill, I don't know what they'll do to you. Who cares? But the worst thing you can do is instead someone that you don't get a good feeling about, and then you spend, $1,000, $2,000, $3,000 to do an estate plan with them, and it isn't really what you want. And it's also not correct. That's the worst, because I've met people who've spent a lot of money on an estate plan, and I look at it and go, yeah, that's not going to do what you say. That's not going to do anything. You're going to have to go and start all over with somebody else. That is the worst thing. And if you get a bad vibe, just leave. It's, I think people get intimidated by attorneys, and I understand it. I know I can intimidate people if I feel like it. And I can. Sometimes that's to my advantage. I try not to do that to actual potential client, I try not to do that. But I know in the past I used to do litigation, and there's an aspect of you want to intimidate the other side. And so I think attorneys can put that out there. But you should not be intimidated by your potential attorney. If they're intimidating you, they should not be your attorney, because that is a very bad sign. And you have to feel confident that you can walk away from a bad situation, because it will get worse. If you're, and I've seen it so many times, people are like, yeah, I just wasn't sure they knew what they were doing. I'm like, yeah, they don't know what they're doing. That can be very dangerous. I will say, if you're using pooled trusts and stable accounts and not using a private trust, it's harder for them to mess stuff up, but it still matters. Now, if you haven't, like, let's say your cousin is an attorney and they'll do all this stuff for you for free, let's have them reach out to us and we'll try and, get them in the right lane and make sure they're not getting out of control. Happy to help out. I mean, I've met with hundreds of attorneys in the state of Ohio and talked to more about, hey, don't do something bad. And if they're just setting up a pooled trust and they're doing a joint agreement, I mean, that's fine. That's not very complicated, and it's fine if that's the right choice for you. And that's the real trick. At Community Fund, we want you to have the right advice so that you have the best option for your child, what you want them to get. That's what's really important. And so that's kind of what our thought process is and how I kind of try and approach it also. So if that helps a little bit, but yeah, I would start at NAILA. I think it's a great resource, and they have people all over the state, but like I said, you might be getting in a car and driving, but I think that's worth it.
I'm just watching the chat for more questions, and please feel free to keep asking. I just wanted to clarify, you had mentioned moving money from a trust to stable. What about stable to a trust?
So you can move money from a stable account to a payback trust, to that first party trust, because that stable account is going to have your child's social security number. It's the individual, the disabilities money. So once it goes into a stable account, let's say they're still getting SSI and they're getting close to $100,000. Well, but they're getting SSI. So now they can take some of that money and put it into a pooled Medicaid payback trust. And then they maintain they're eligible for SSI. But that trust has a payback provision. Now, it might be that I talk about these payback provisions and, Medicaid's going to get their money back. But sometimes, especially if your child is living with you, they might not be on Medicaid, right? They're on your health insurance until they're 26. They might have a job at Kroger that pays for their health insurance. They just might not really be getting anything from Medicaid. So Medicaid might not be owed anything if they pass away. When they pass away, it's not a guarantee that Medicaid's going to get any money. Medicaid now, if they're on their health insurance, they'll get money, and if they Medicaid will source, because the premiums are insane. And then if they're getting any of the waiver benefits, Medicaid will be owed something. But if let's say if you have a child on Medicaid right now, you can go and make a request to the Ohio Department of Medicaid to tell you exactly how much money Medicaid has spent on them up to date. And you send them the request, and they'll send you back a detailed explanation of every penny and where it came from. It's quite fun to do, actually. It's always a 6-month lag. So they're not guaranteeing it's the most up to date, because it can take up to 6 months for things to be reported to the state, but it does kind of tell you like, oh, okay, well, this is how much Medicaid's going to be requesting upon their death, or if they're going to request anything at all. So that's kind of an interesting thing to look at in that way. So I have another fun example of spending money out of a trust. Again, this is not a community fund client. This was on a listserv that I was on, where a young woman in her early 20s had about $40,000 in the trust. And she asked the trustee of her special needs trust, of her pool trust, if they would pay for a breast augmentation. And so the executive director was like, can I pay for this? And everyone was like, well, yes and no. And so given that she was in her early 20s, the consensus was that they shouldn't pay for it, because breast augmentations have to be redone every 10 to 15 years. And given her age and how little money was, I mean, $40,000 sounds like a lot of money, but if you're in your 20s, it's really, and you're not earning otherwise, then it's really not that much money. And so we were saying there wouldn't be enough to pay for them through the rest of her life, so they shouldn't actually authorize it. But if that same trust had had $400,000 or $300,000, everyone would have said, sure, yeah, go ahead. And that's an allowable expense out of a trust. It's also an allowable expense out of a stable account. Those are things that they can pay for, which and you can say, well, that's crazy, but if it makes the person happier and living the life that they want to live and they have the money to do it, then why not let them do it? So it's kind of like bail. I once had somebody who used to be on the board of community funds say, we don't pay for bail. That's horrible. And I'm like, well, they're innocent until proven guilty and the court authorized bail. We're going to pay for bail. If they want to get out, they can get out. They're guilty, they should stay in, but they got bail. So some of those weird things that you don't think about, but when it's your life, you care about that stuff. Well, one of the other expenditures that we used to see a lot, less and less though, is like Playboy and those kinds of magazines. We community fund will pay for those. They are an allowable expense. And I'm not actually sure. I think that they would be under Stable because I don't think Stable would catch on to it. But if they did, they might not say that because they have some morals things in there. But community fund would pay for those. That same board member was like, we don't pay for smutty magazines. I'm like, oh yeah, we totally pay for smutty magazines. If that's what the person wants, let them have the magazines they want. So, so those are some weird things that are interesting, but true. So I like the idea of us paying for service animals more. It's cuter, but it's just
your part on the house, you were mentioning about a house. We have our houses and stuff, assuming, well, not assuming, when we pass away, and you want the child to continue to live in the house and you don't want anybody selling it out from under them. Is that, you're talking about selling a house and the money into a trust, but if you don't want to, you can put a house in a trust, right? Just the house.
Correct. Yes.
Yeah.
So again, you can put the house in the trust, or the house can be in the individual, the disability's name outright, or jointly with their siblings. Here's the problem. If I put the house jointly with the siblings, then the siblings can force the sale of the house because they own it. And if they don't want to own it anymore, they can force the sale of it. So that's where if I just say, okay, I'm going to name my 3 children as owners of the property. Well, you could, and then Johnny, who has special needs, gets to live there the rest of his life. Well, maybe not, because you put it in the 3 names. But if you put it into a trust, then there should be language in the trust that says Johnny gets to live there the rest of his life, unless Johnny, his social worker, some other people agree he can't live in that house anymore. So it's not just the kid, it's not just the siblings deciding he can't live there. You want to put language in that some outside group has to review the situation and agree that Johnny isn't safe there on his own, that he's not getting the care he needs. Or, mom and this, I see this, mom, oh, he should live in our house. And it's like, it's a 4-bedroom, 3-bath home. You don't want anyone else to live there. The carrying costs of this house are enormous. This is crazy, like trying to find someone to mow it and replace it's just too expensive, when really a condo would make so much more sense and be closer to the other siblings. In those situations, you do want to leave some flexibility so that you want the trust to be flexible enough so that everyone can pick the situation that's best for them and make adjustments. Because the other thing that happens is the neighborhood changes. And that is, long-term, you don't really want to keep that house in the depreciating neighborhood, because then by the time they pass away, you really, you have an albatross, or really they're not safe. And you're having a hard time finding caregivers because it's no longer a safe neighborhood. And that does happen. And so you have to leave some flexibility in the trust that they can sell the house. You want to put some language in there that protects the individual, but you do want to you have to let them sell the house, because stuff happens over time and you need to address that. And I see that a lot, like, oh, mom and dad, they like their house, but everyone else is going, this is not such a good neighborhood anymore. We know you like everybody, but it's not good. But more, like I said, and sometimes you just can't get caregivers because it's not that nice of a neighborhood anymore. And people don't want to work at night or whatever. And then you have a real problem. So that's why it's important to have some flexibility. But yes. But when you want to have the house like that, you're going to have a private special needs trust. And And so then if you're going to do that and you're going to have a bank be in charge, there also has to be a decent amount of cash. And you want to make sure you've met with the bank and that they're agreeing to take on this trust upon your death. Because if you pick US Bank or Fifth Third Bank and you have $100,000 house and $25,000 cash, they are not going to be the trustee. They can't get a fee out of that, and they're going to run it out of cash so fast, it's a nightmare for them. And so you have to know what you're getting into when you're making these plans. So that's really important, because if you don't have enough, I always say that you're going to have a house and about at least $200,000 cash to keep the house going. You know, that's usually what I'm thinking of when I think of a trust, because with a house in it, presuming that the mortgage has been paid off. If there's a mortgage, you got to pay the mortgage off first and then have at least 200,000, because over the lifetime of the home, I might have to replace the roof. I might have to get a new furnace. I remember I got to mow it all the time. I got to pay property taxes. You know, sometimes you got to paint stuff, the plumber. I mean, there's just expenses. And so that's also why I feel like homes are not necessarily the best choice. I like a condo better, because now you've limited a lot of the cost on those things. But condos aren't always the right choice, especially, you know, we have kids who, because of their disability, they're very loud, and a condo is not a good situation, you know, so there are lots of different things to take into consideration, but you want to make sure that you're addressing this and that you're holding back the cash to keep the house going. Because once the trust runs out of cash to keep the house, the trustee has to sell it. Doesn't matter what you want. If there's no cash to pay for it, and your typical kids aren't willing to cough up the cash to pay for it, then it will be sold, because the trustee can't let the only asset depreciate, you know, go to a foreclosure or something like that, go to tax sale. So.
Very good points when considering that. There's a lot to think about. Parents have a lot to think about, because we have to think of, like you said, the situation of the neighborhood. You know, you might think of the house right now, but like you said, things could change.
Yeah,
and change is something you just can only try to predict. It's something you don't know 100% about.
Exactly. Yeah.
I'm going to go ahead and stop the recording. And then anybody has any more questions, you can feel free to raise your hand or ask. But I want to thank Laura for tonight for all the information. We did record it, so it'll be available for you to review it if you want to review something, or reach out to Laura if you have any questions. If you missed her email, I don't know, Laura, if you can throw it back in the chat box.
Yep.
But I kept it up as long as I could, but then you can just throw it in there too. But while she's doing that, just thank you everybody for coming, and for those who are listening. And I look forward to, learning more about this. It's something to sort through. It's quite a bit of information to sort through. So 1 second while I end close the recording.
Yeah. And so then Patty, Janet wants to know how to find the link to watch the recording in the future.
We'll put it there in the, Michelle, if you can, there she goes. We're going to put it in the YouTube, and I also have created a website, and then we'll try to upload it to that as well. So 1 second while I stop the recording.